Okay, welcome everybody. Today I'm visiting some patent lawyers. I'm at Taylor Wessing here in the Netherlands, and I would like to learn from them a little bit more about what patent lawyers do, what litigation is, and maybe you can first both introduce yourself and tell a little bit about your company. Can I start with you, Wim?
Yes, thank you. My name is Wim Maas, patent litigator, partner at Taylor Wessing. I can explain a lot about patent litigation, but I will keep it very brief. What I do is when patent protection has already been obtained and there is an infringement, then you probably will call me or one of my friends who also do patent litigation. And then I will try and help you as best as possible to try and obtain a victory in court. Very short, before I hand over to Eelco, my colleague, about Taylor Wessing. Taylor Wessing is a full service firm. So what they do is not only patent litigation, they also do M&A, corporate employment, corporate disputes, and so on. But they have a very big international patent litigation group divided over the offices in the UK, in Germany, the Netherlands, Brussels, Austria, and many other European venues. But that's in short about our firm.
Yes, thank you. My name is Eelco Bergman. I'm also a patent litigator and a partner at Taylor Wessing. And I work here for 14 years side by side with Wim on various patent cases that we have been dealing with.
Yeah. So we've been talking about patent cases. You got patent owners and people that use technology might be patented. Do you work for both type of organizations or for one side only?
We do work for both sides. So that means that we work for the patentees and we also work for people using patents, implementers. Typically, I'm mainly working now for patent owners, the last 10 years or so maybe. But we also do a lot of defense work still. For instance, in medical device, we did some patent assertion work, but also defense work.
Good. And Eelco, if people end up in court, should they prevent that from happening in the first place? Is it a wise idea to go towards the directory of courts and involve people like you? Or are you maybe involved even earlier than when it starts out in the courtroom?
Yeah, that's a very valid question. Yes, court cases don't come out of nowhere. Of course, they build up. When a patentee comes across of an infringement of its patent, it's wise to advise a patented lawyer already in the process to see what the process entails. And usually it starts off with writing a summons letter, for instance, to the infringing party, and then it goes without saying that we also on the basis of our bar rules, we should avoid going to court as much as possible. So that's why we also send summons letters to an infringing party and then try to see whether or not we can get to an agreement with the infringing party. For instance, a license. You can grant a license of your patent. But if that doesn't work the way that you want it to be, then yes, there's the assumption of going to court. Yes.
And sometimes perhaps it's unavoidable. You just don't manage to agree in any other way than having a judge having a verdict on it, right?
Yeah, exactly. Yeah.
So talking about these different type of clients, what are their needs? What is the kind of the line of argument or defense for a patent owner or a user of technology? Can you maybe say a couple of words, one of you two?
What are their needs? When you go to a patent lawyer, patent litigator, then typically there is already a dispute. That dispute means that they probably, not in every case like Eelco just explained, but they already try to resolve the dispute amongst themselves. And typically they didn't succeed. And from some moment in time in this process, they believe they would need some strategic advice. So I think what they really need from us is strategic advice, painting the picture of the options they have. What if this process will end up in court? What are our chances then? And at some point in time during the negotiation process, they are in need of this strategic advice so that they can better assess what they should maybe give away in the negotiation. Because if, for instance, we would say that they don't have a chance in court, then they know that they really need to try and settle the case. And we can still bring them with additional arguments they could use to have more leverage, to try and obtain a better settlement. But I think they are mostly in need for strategic advice. And then zooming into what kind of strategic advice that would be. Is the patent valid? Is the patent infringed? Are there any other defenses, license defenses, exhaustion defenses? I can talk a lot about these legal concepts, but these are in general some of the advices they need of us, and also more strategic in a way. What will a judge think of this? Even though we are right, will this judge be convinced of our arguments? Do they think we have a sympathetic case? Do they like us? How should we present our case that they like us more than that they like the other party? And this is true for Europe, but this is certainly also true for the US, where you plead for a jury, where I always believe that sometimes a lawyer like us also needs to be a little bit of an amateur psychologist.
I was just going to say that it includes psychology as well, it seems.
Exactly, yeah.
Right. Coming to the next question, you've both been working now for already quite a few years in patent litigation. Can you maybe tell us something about your most remarkable or exciting case? Something you big back like, well, that was an interesting thing going on right now. Could be any technology or so. Maybe you want to go first, Eelco.
Yeah, thanks. Well, I think there's one thing that is keeping us busy for a year and a half now, which is the newly set up Unified Patent Court. That's a new court with several locations throughout Europe. And you can go to one location of this new Unified Patent Court, for instance, the local division in The Hague, or a local division in Italy. And you can go there and you can get an injunction or a judgment on the validity of the patent, or a declaration of non-infringement if you are interested in in getting a declaration from the court that you do not infringe. And this decision will be valid in 18 different European countries. This new court has been set up as of the 1st of June on 2023. And I think the most remarkable moment in that new system, I mean, it's exciting to be part of this new system and be part of shaping and developing the case law in this new system. And Wim and I had a case in Lisbon, before the local division in Lisbon, which was the first PI proceedings, which are the preliminary injunction proceedings, before the local division in Lisbon. And it was very exciting to be on the ground, working, preparing for this case, and then working up to the moment of the actual oral hearing. That was really exciting for me.
A new course, a whole new things. And can you tell something about a case that excited you?
Yes, many cases actually. But I do want to also second the Unified Patent Court. And I do also have some cases of which I think they were very remarkable, and I will never forget those cases. But the Unified Patent Court in itself is very adventurous for us. Always only having to go to the Netherlands and now having to litigate in a system within Europe excites me every day now. But okay, your question, a court case which I never forget. It's actually not a patent case, but I'm going to say it anyway. When I was a younger lawyer, I think I only maybe practiced law for 2 years. I was asked by the senior partner in my firm to work for M&M. And it's not the candy I'm referring to, it's the wrapper. So I have no clue when I was younger, this was a famous rapper, and understanding from my kids that this guy is still somebody people know. So I was asked to represent Marshall Mathers III which amazed me that I had a case for him. And then at some point in time, his manager, still remember his name as well, Paul Rosenberg, he requested a meeting with the legal team representing his client, Marshall Mathers, M&M. And the legal team was me. I was by myself. It was a small case, but the US approach to cases is that they deploy maybe 10, 15, 20 people. But this time it was only me, and we met in the Grand Hotel. And afterwards we did the case. And that was actually my first case. I pleaded in court, but also for a client everybody knows. So. But I can tell you a lot about different cases I still remember. We did a lot of cases together, smaller patent cases about mechanical engineering, but maybe I can talk about it for hours.
We had a case about a telehandler, which was fun to be
Yeah.
discussing and debating on before the court of first instance. We did so many great cases, actually.
And so still interested in one more case about the product, maybe something we all know. Is there any case that comes to mind that you said, well, that was spectacular or interesting to do?
Yes, many cases, but another case which I am also very proud of, even though it ruined maybe one of my child dreams a little bit. But I worked for Mega Brands, and Mega Brands was, and I think still is, a Canadian manufacturer of toys, and they came up with their own Lego brick. And of course, it was not referred to as a Lego brick because then it was a clear trademark infringement. But it was the brick itself and different playing bricks. Lego also has in its assortment, so to say. And they introduced this on the European market. And Lego, of course, fought it really hard. And we were asserted with trademark infringement as well, even though there was no real trademark infringement, copyright infringement, slavish imitation, and in the end, the court case was more about slavish imitation than it was about copyright infringement. And it went up to the Supreme Court of the Netherlands, and we won that case. So in the Netherlands, it is now allowed to bring your own Lego-like brick on the market because the monopoly, there was no patent protection anymore. That's important to stress, I guess. The patent protection already lapsed. And it is now also possible to bring these Lego kind of products to the market, which I really like because the case was about Lego, which I think many kids and some, actually I have to admit, I also played with Lego during the COVID crisis. I still love it, but that was a remarkable case.
You didn't totally kill the company. It's still there around and it's still doing good. We have to come to the last question of the talk today. And I want to ask, is there any message that you want to give to our viewers? Anything that you want to share about your field or to students perhaps?
Yes, what comes to mind? It depends on where you're going to work, right? But I'm now assuming that you're going to work within a tech company and you will maybe be engineers within that company. And then it depends on the policy the company already has, but maybe you also have influence in that policy. And for me, I'm an advocate for patent protection. I really believe that patent protection does steer innovation, it does stimulate innovation. But I know there are people out there who think differently. They think that maybe patents are blocking innovation. I'm on the other side of the spectrum. I believe in people will be motivated by a monopoly, protection for their invention. They will be motivated to invent new things. And also other people who learn from these patents, because these patents are publicly available, they can also learn from this innovation being available for the market. So I think my message to you would be, invest in patent litigation. In patents. Important. Don't invest in patent litigation, only when necessary. But in patent protection, I really believe it will steer your company to greater innovations. But I actually think I stole your answer, because that is also a message you had, I guess, maybe.
Not really, but I think I can add to your answer because the students might not all end up in the policy making within these tech companies, but also if you are outside of the policy making industry in these tech companies, then I think it's fair to say that you should be aware that patents exist. And that it is something to take into consideration when either inventing something new yourself so that you can apply for patent protection perhaps, or that you should probably also be aware that other people could have patented something and that you might become or be aware of the fact that you could potentially infringe someone else's patent. So keep that in mind, and maybe whenever the opportunity arises, try to reach out to either a patent lawyer or a patent attorney for further assistance on that if you ever come across such a topic.
Okay. Thanks to you both for talking with us today, and hope to see you soon.
No, I appreciate
you.
the talk. Thank you.
You're welcome.
Thank you.
Thank you.